Thanks everyone for joining today. We have a lot of participants here. My name's Seth Bloom, and I am the Senior Director of Attorney Services at Levelset. We're really excited about our webinar today. If you have any questions during our speakers program, please just type them in and we will ask them live. Otherwise, you can post them on the Attorney Network where you can ask a lawyer. And you can always contact Mark just additionally by calling him straight to his law firm. So I'm really excited today. We have Mark Cobb, and he's from the Cobb Law Group, and they are based out of Atlanta, Georgia, with a secondary office down in South Georgia that we were just talking about. So I'm really interested in this cutting-edge law that Mark was a big part of in Atlanta and in Georgia, and that's Georgia's new lien law changes. Look at Senate Bill 315. So, Mark, thank you so much for joining us today, and we look forward to hearing what you have to say.
As Seth said, we are a construction law firm. It's all we do. We handle all aspects of law for our clients, from complex litigation matters, delay, liquidated damages. My focus is on construction contract drafting and negotiation, as well as payment issues. And that involves materialman liens, payment bonds, Miller Act claims, and similar issues related to that. From our two offices, we try to support clients throughout Georgia, but we have really a regional practice. And most recently, I was on a drafting committee to help change Georgia's lien laws to make them better for those in the industry. And that's what we're going to be talking about a little bit today. So let's get started. Let's take a look at the first slide, which talks about Georgia's lien waivers. They've been unique since about 2010, which was the last substantive change to Georgia's lien laws. What makes them unique is that they're conditional for a period of time, and then they switch to becoming unconditional. What does that mean? Well, condition is there's a condition precedent before something happens. So another example on a construction site might mean if my crew damages another part of the project, then I will pay or indemnify the owner or general contractor for the damage that we caused. That's condition. That's a condition that something had to occur that you're responsible for, and then if you're found responsible for that condition, you will then pay that. That's what happens with a conditional lien waiver. It's conditioned upon payment. So if I receive X amount of dollars, then I will waive my rights to a lien. An unconditional just says, I'm going to pay for everything. I'm going to pay for all the damage on a project. No contractor or subcontractor is going to sign that document. But if they did, it would be an unconditional waiver. So in a lien waiver scheme, an unconditional waiver just says, I waive my rights to file a lien. Georgia only has one lien waiver. Well, really, there's two. There's one form. One's interim, the other's final lien waiver. They're substantially similar. And they start out conditioned upon payment. So if I receive X dollars, I will waive my rights to file a lien. However, under current law, on the 60th day, that lien waiver converts from a conditional lien waiver to an unconditional lien waiver. So on day 60, it doesn't matter whether or not you have received the money that you're owed, you waive your rights to file a lien. That's a big deal. And the only way to thwart that is prior to the expiration of the 60 days is to either file an affidavit of non-payment or to go ahead and file a materialman's lien. Otherwise, again, and this is very important to understand, that current Georgia lien law is conditioned for 60 days. After that, it's unconditional. Most practitioners, most industry professionals have always assumed and taken the stance that this lien waivers only apply, as the name suggests, to lien rights, that it did not affect other rights that contractors or subcontractors may have in Georgia. On the next slide, you'll see that there's a style of a case, ALA Construction Services versus Controlled Access. ALA Construction Services was a contractor who was hiring subcontractors and asking them to sign lien waivers with their pay apps. At least 3 of those subcontractors did not get paid within 60 days. And so they sued ALA Construction Services for payment under their contract rights. In the lower court, in two of those cases, one lower court said, well, you know what? You signed a lien waiver and it only applies to lien rights. You still have your contract rights after 60 days. But another lower court said the opposite. It said, well, the lien waiver really applies to everything. So after 60 days, you don't have any contract rights. Needless to say, both of those cases were appealed to the Georgia Court of Appeals. In September of last year, the Court of Appeals came in and reviewed different sections of Georgia's lien laws. First, it considered what the lien actually says. This is required by statute. And the lien says that you shall be conclusively deemed to have been paid in full, even if you have not actually received such payment within 60 days.
Mark, sorry to interrupt for a
Yes.
second,
Sure.
but I just saw our first question come in and I didn't want to get backed up. Sarah asked, are the waivers statutory forms?
They are statutory forms. The way the statute reads is that you have to have a lien waiver that substantially complies with the Georgia statutes. And there's a lot of technical things required in Georgia's lien waiver. For example, it has to be all caps, has to be 12-point font, and it has to have the notice that I was just referencing that says you shall be conclusively deemed to have been paid in full. That has to be on the form. So the Court of Appeals did look at the lien waiver. The Court of Appeals also looked at the underlying statute, which this also is where you'll find the statutory version of the form, but it's Official Code of Georgia, OCGA, it's section 44-14-366. So in addition to having an example of the forms for the interim and the final lien waivers, it also says that lien waivers shall be binding against the claimant for all purposes. So using those two sections, the part that's actually found on the lien waiver and the part that's in the code governing lien waivers, the Georgia Court of Appeals said that the waiver is considered binding against the claimant for all purposes, not just lien rights. So in other words, I've had plenty of clients who may be on slow pay on a project. They're getting paid 60, 70, maybe even 80 days from the date of a pay app. They have a relationship with the contractor or the owner or the developer. They're not terribly concerned about the lien waivers they've signed because they know they have contract rights in the event of non-payment. However, this case, ALA Construction Services versus Controlled Access, upset that strategy completely. So now, if you have a lien waiver in Georgia, it's a proper lien waiver, statutory form, and it's not paid within 60 days, you not only waive your lien right, you waive your contract rights. You waive rights to unjust enrichment. You waive rights to quantum merit. You waive all of your rights because you're deemed to have been paid in full. That's a big deal, and it's hurt a lot of people in a lot of ways. So within a couple of weeks of this holding being released, several organizations got behind wanting to change the
Mark,
statutes.
do you mind, just for my own, maybe make it easier, just if you could explain what the difference is like in some of those changes, like what quantum merit really means and how this could really impact getting paid and what you're going to get paid, just to maybe break it down a little bit.
Sure, break it down.
Yeah.
It's kind of easy to say that, Seth. If you have a lien waiver and you don't receive payment in the 60 days, you're not getting paid. You cannot pursue them for contract rights. So your contract may say something else that you have other rights. You cannot sue them for unjust enrichment, which is a theory that says the work that I've performed on your property has increased the value of your property, therefore I'm entitled to compensation. Quantum merit is a fairness doctrine and equity that says something similar. You know, I built your walls. I should be paid for your walls. So unfortunately, if you have a lien waiver and you're not paid, you are out. You will not be paid. There's no legal mechanism to force payment.
Right. Thank you.
So moving on to the next slide. After this adverse holding came out, I mean, it sent shock waves throughout the entire industry. And I would like to point out that that holding is still good law in Georgia and will be good law in Georgia until December 31st. But last October, just a few weeks after the holding was issued, AGC, Associated General Contractors of Georgia, began a move to revise Georgia's lien laws. They put together a panel, included 3 lawyers. I was fortunate enough to be on that panel, and we sat down and we went through the holdings of that case and a few other cases that had come down, and we decided we wanted to try to push legislation through in the 2020 legislative year. So we had about 6 weeks in order to get it to get it finished before the first deadline, which fell in December. That's when it actually goes to a sponsoring member of the legislature. So we worked at live meetings, Zoom meetings, email exchanges, trying to come out with a language that would actually help the industry. Real quickly, it was fascinating to watch this happen so quickly. That seldom happens when you're trying to change the laws. More importantly, this also happened in a year where the Georgia's legislature took a break because of COVID-19. So the process began normally enough in January. It went before the Senate. It had 43 senators sponsoring it. We only have 56 senators. It passed it passed the Senate unanimously. On the day that it was going to go to the House for consideration, that is when the pandemic officially began and businesses began shutting down, including the Georgia House. Georgia House took a recess. They reconvened in June. When it was finally presented to the Georgia House, it passed unanimously in the Georgia House. And on August 5th, the Senate bill was signed by Governor Kemp into law. And it will take effect starting January 1st in 2021. A couple of the big changes that this bill, now law, makes is that it specifically limits lien waivers to waiving lien rights. So to break it down, if you sign a lien waiver and you're not paid within prescribed time, and you choose not to file an affidavit of non-payment to void that lien waiver, you still have contract rights you can go after. So you won't have lien rights to file against the owner, but you will have contract rights against whoever hired you, which may be the owner, may be a general contractor, could be a subcontractor. Another big difference is that 60-day window. And for those of you who have spent any time watching payment flow on construction projects, you realize that 60 days is a very short time frame. That 60-day window to be paid or file an affidavit of non-payment has been extended to 90 days. So you get an additional 30 days. And I think that's going to really cut down on the amount of affidavits of non-payment that need to be filed. That 30-day window seems to be a very 61, 65, 68 days seems to be a very common window for people to actually receive their payment. Furthermore, if you remember earlier, I said that the existing law and the 2010 lien waivers said there were 2 ways to void a lien waiver. One is to file an affidavit of non-payment. The other way was to file a lien. A few years ago, there was a court case that said you cannot file a lien. There's some exceptions, but you really can't file a lien unless you are finished with the project. Therefore, we felt like that was misleading people who might read the statute and think, oh, I can go ahead and file a lien even though I'm still working on the project. So we took that out. So the only way to void an affidavit of non-payment is to file, the only way to void a lien waiver is to file your affidavits of non-payments. And to remind you, they have to be filed starting January 1st. They have to be filed within 90 days of the date of your lien waiver.
Mark, were there any particular interest groups on either side that had presented obstacles for you?
We were expecting some pushback from some groups, most particularly the banking lobby, simply because in Georgia, unlike other states, construction lenders can have to take priority over material and liens. And so whenever those laws get tweaked, they always take an interest. We were concerned that the banking lobby might push back, particularly against that 90-day period in lieu of the 60-day window, because it opens up the door for maybe a bank being, it slows the deadline for a bank possibly to know when there's a payment issue or there's some issue on the project. But thankfully, they didn't present. They were satisfied with our changes. They accepted them. And in addition to that, we had over 20 professional organizations join in this one. So not only was it a charge led by AGC Georgia, but also ASA, American Subcontractors Association joined, Construction Suppliers Association, the Georgia Chamber of Commerce. The list just goes on and on with all the professional groups who supported the changes to this bill. Again, it was unanimous in the House, unanimous in the Senate. Governor signed this, and all these professional organizations, because that holding was devastating to those in the construction industry in Georgia.
I think Levelset needs to do another blog about all these changes. Maybe
That's
Mark,
right.
We should put something together.
Absolutely.
There's a lot to this.
There is a lot. And, again, it's getting down to the weeds. Payment should be one of the easiest things. We submit a pay app, 30 days later, we get paid. Unfortunately, it's never that easy. And, these statutes complicate it. Hopefully with these revisions, we've given construction professionals a little bit more wiggle room, 90 days, and more importantly, we preserve all their rights except lien rights, which understandably at some point lien rights need to expire.
Sure.
And so now they do 90 days. So that's very good.
Mark, I'll take a second. We have a bunch of questions coming
Great.
in, and just for everyone to know, these will be available on our website. They will also be available on Mark's website to watch this presentation and get these slides again. I know I have a lot of questions coming in for that, and I'll say, Mark, we have a really big crowd, so this is a great webinar for us today. But I will get to some actual questions. So Kevin asks, so as of January 1st, 2021, will the approved Georgia waiver notice language at the bottom of the form be changed to say 90 days in lieu of 60?
Yes, it'll be changed to say 90 days. It'll also be changed to reflect that it only applies to to lien rights. And I will also say this is good segue in offering this. Lien waivers in Georgia have always also applied to payment bonds. It has just never been prominent. Now we've made it more prominent. We've included it now in the title of the documents, and in that notice provision, it does say that it only applies to lien rights and payment bond rights. It had said that before, but we wanted to highlight that so there's no misunderstandings.
Okay, and Sarah just asked again. She says, "I'm assuming the affidavit of non-payment is statutory as well."
It is. It's in the same code section, and so basically the mechanism is you submit a pay app. Currently, you monitor that payment for 60 days. Starting January 1st, you can monitor it for 90 days. We tend to recommend about 10, 15 days before the deadline, you get an affidavit of non-payment filed. And it's a statutory form in that same section. It too is all caps, and it's kind of an ugly form. And it's filed in the courthouse in the county where the project is located.
Okay.
And just to throw this out, if you file an affidavit of non-payment, down the road, hopefully you will receive payment in full. When you do, you're supposed to file an affidavit of payment, which is yet another form in that same same code section. And it is also filed in the courthouse where the affidavit of non-payment was filed. Sorry, all these words, even for me, just sound so similar. I want to make sure I get the right word, say the right word so that everybody listening gets it. So
I'm going to let you, the questions are coming in,
great.
A lot of them, which is great, but I think I want to let you go for another minute or two because you probably answered some of them.
Okay.
But if not, we'll circle back, and we're always going to leave plenty of time in the end and try to get as many questions answered. And Mark's been gracious enough to offer some extended time if needed, but it looks like we'll need it. So I'll let you go for a minute, Mark, and then I'll stop you.
Sure.
Some more questions come in.
That's really the substantive change. I think we've got one more slide with some practical tips, which may answer some of those questions. But when you're looking at a lien, when you're looking at sort of the process, pay app with a lien waiver is a very typical scenario. Monitor the deadline. If you're not paid, file that affidavit of non-payment, then because that voids the lien waiver. If you file an affidavit of non-payment, then when you get paid, file an affidavit of payment, and that voids the affidavit of non-payment. don't you love lawyers and legislatures for doing all this? But the bottom line is this statute preserves every contractor's right to money, to receive the money for the work that they performed. You know, this could not have been more vital since this holding has come out. September, so that's what, 11 months ago. We have gotten repeated calls from contractors who have been caught in this trap where they waited more than 60 days. And I've had to relate some very bad news. I mean, someone calls me about a $200,000 amount they're owed on a project. And one of my first questions now is, did you sign a lien waiver? How long ago did you sign the lien waiver? It's been more than 60 days. Sit down. I've got some bad news for you. Now, there are some honest contractors out there, and they have played by the rules we've always had. And so, but the only option for getting payment is somebody who wants to treat you fairly right now. And so it's still important between now and January 1st that you monitor that 60 days. Other questions, Seth?
Yeah, we've got a bunch of them here. So I'll start with Chris at the top, and I must have missed him because he asked it a few minutes ago. But Chris asks, why didn't you attempt to change the feature of the law that requires a conditional waiver to become unconditional when it is obviously unfair to the materialman when he hasn't been paid and loses his lien rights?
Sure. Great question. We anticipated a great deal of pushback from the bank lobby on that. When you've got a construction lender, they need to know a date certain when rights evaporate. And so that is part of the point behind that. Secondly, you still, as a subcontractor, as a materialman or a sub, depending on doesn't really matter what tier you are, you still have the rights to file the lien. And we've got you an additional 30 days to preserve those rights. If you are, sometimes people, liens are a wonderful tool for helping you get paid, but they're not the only tool to getting you paid. And so our focus was to help extend lien rights, but more importantly, keep those other tools in your toolbox so that you get paid. Contract rights are far more important than materialman lien rights. If you have a materialman lien, but you can't prove you have a right to payment in the first place, you can't perfect your lien, you can't foreclose your lien and won't get paid.
Okay. And Stephanie asked, since HUD trumps state lien laws, how do these laws affect Davis-Bacon?
These lien laws do not affect any federal projects at all. It only affects Georgia private projects and Georgia public works projects, state, municipal, city, county.
Okay. And Sherry asked, how does a vendor service agreement compare to a contractual obligations for a specific job?
That's a difficult question to answer without reading what that service agreement actually says. But it is a type of, it can be construed as a type of contract. If you're talking about some of the terms and conditions, we use those pretty regularly with our clients to make sure that they're as ironclad as they can be.
Okay. Sarah also said she came in a few minutes late, and she wanted to know if notices are still the same or if they've changed at all with this new law.
The statutory scheme for like notice of commencement, notice to owner, they're still the same. So an owner or GC files a notice of commencement, and then subcontractors and suppliers to subcontractors have 30 days to get their notice to owner and notice to contractor out.
Okay, and I think we've gotten this one a few times. Just to be clear, you might have answered it, but where can they get the location of the statutory forms with this new language? Do you have it on your website, or maybe it's something we should post?
Not yet. We're going to intentionally wait and post this in December.
Okay.
Because if people use this now, it won't be enforceable at all until January 1st. So, but they can find it at OCGA Official Code of Georgia. It's 44-14-366. And we're going to be circulating it to our clients. I'm sure Levelset's going to be putting it out on some form. We'll have it available on our website later on. It's a little early. We're really gearing up for education right now and for the big change, because I don't want anybody to think that it takes effect now. That would be potentially devastating. Yeah.
A lot of things going on. That's Tough timeline. So, yep, we keep having questions coming in, and we love this. So, Mark, we'll keep this as a Q&A.
Fun.
Susan asks, if you do not file the affidavit of payment, are there any legal ramifications?
You lose weight. If you don't file an affidavit of non-payment within the currently 60 days, soon to be 90-day period, you lose your rights to lien. Right now, until December 31st, you lose all rights to payment. You will not get paid. After January 31st, you still have your right to seek your payments under your contract.
Sarah asks, are there waivers taking place of the notice of contractor / owner?
I'm sorry, you meant to repeat that question, Seth. I'm sorry.
Yeah, we may have a typo or two.
Mm-hmm.
I'll come back to that one.
Okay.
Does the conditional lien waiver need to match the statutory forms exactly, word for word? And that was asked by Jim.
Sure. The statutory language says it has to substantially comply, and so we tend to not change any of the words, but occasionally we do change words depending upon the specific nature of the project and the risk involved. Another example is currently the code says that notice language, the language which says you shall be conclusively deemed to have been paid in full. Currently, it's required on the face of the lien waiver, which means front page. We've removed that. Similarly, the all caps has been removed. In January 1st, the new lien waivers will not have to be in all caps. So we've tried to change the format a little bit to make them easier to read.
Okay. This one's pretty general, but we'll throw it out here. Maybe there'll be some meat on it. How does a general contractor set up a contract with a homeowner given this new law?
In the homeowner situation, rarely do we see homeowners requiring lien waivers. I think it's a great idea. If I were building a house, I would require a lien waiver, but I don't really see those. So as a general contractor, if you're a home builder, you probably do want them from your subs. That way those subs can't come, there's a deadline as to when the subs can come back and actually lien your project. And so I would put that as a requirement in my contract with the subs.
Okay. We'll keep going. Lots are coming in. From Stephanie, do you recommend any contract language stating that you will not provide a lien waiver for unpaid work or unpaid retainage?
If I were to do that, it would depend upon the relationship you have with the whoever you're contracting with. What we find is a better situation is actually vetting your general contractor or vetting your owner. It amazes me how few people do that. Maybe that's a seminar topic, Seth, we can put together sometime. But
yeah,
if you look at even just the lien record in Georgia, which is public record, if you Google, look for newspaper articles, you tend to find out who the good GCs are and who are not. Same way with developers. It may take a little bit more work with developers for the Secretary of State's website and find.
You can go to contractor pages at Levelset. We can tell you that too.
There you go. But due diligence will help prevent those problems.
All right. Melody asks, will there be any conditional and an unconditional waiver, or will they be one and the same?
They're one and the same. They're substantially it's the same idea I expressed before. There can now, starting January 1st, lien waivers will be conditioned upon payment for 90 days. On the 90th day, they will convert to unconditional, but only as to lien rights.
Thank you. Pam asks, some contractors have multiple waivers they require per their contract. Does the Georgia lien waiver supersede all others?
Great question. The others are not enforceable in Georgia. So I kind of don't care. I tend to not care if my clients sign it. As to lien waivers, you do have to be careful, though, and still review what they say, because you may be waiving other things besides lien rights, and those might be enforceable in Georgia. So, example, you might be waiving rights to file a personal injury claim or theft or damage claim, which is unrelated to lien rights.
Okay. Some of these questions have been answered, so I'm just trying to, this is a good problem to have. What is the deadline from the last date of furnishing with and without a bond?
On public projects, you have to give notice within 90 days of the last day of furnishing if you're going to make a claim against the bond. On private projects, every one I've ever seen has been 90 days, but on private projects, you are dealing with a private contract between an owner or GC and the insurance company. There's no statutory language that dictates how long it must be. So in theory, they could, in a private project, reduce that period or expand that period.
Going through these, probably going to wind down the questions. We're a few minutes over 10:30. Should general contractors change its lien waiver forms in the middle of a project?
I think they'll have to do that. I would, have one form through December, then a new form in January.
Okay. First-tier subcontractors and suppliers are not required to file notice to owner / notice to contractor, correct?
That is correct.
Mark, this is like a bar exam.
Hope I passed.
So far, I'm not cross-referencing you, but it sounds like you know what you're doing. So everyone out there, if they need someone that really understands this work, it's clear that Mark has a mastery of it, because I know we're throwing at him a whole lot of questions in different areas, but we really appreciate it. Mark, is there any other stuff you have to say or final words? And there's a few questions that are still left, but I think we've answered most of them. And I just want to tell everyone out there, go to levelset.com, you hit ask a question, you can post these wherever you are in Georgia, get other lawyers to answer the questions, or call Mark directly up at the Cobb firm and, hire him, tell him you need a lawyer, you got some problems. Hopefully he can, help navigate those. So Mark,
Sure.
Is there anything else you have? And I know there's still questions coming in here, but I think, most of them have been answered. Sherry, let me go to Sherry real quick.
Yeah.
Sherry, she goes, does the current 60-day time frame or the new 90-day time frame still start from the last day you were on the property?
No.
Good question.
As it relates to lien waivers, it starts from the date of the lien waiver. So in theory, you're doing a lien waiver every month with each pay app. And so you're having to constantly monitor the date of the lien waiver and when the payment arrives, and whether or not you need to file an affidavit of non-payment.
Great. Well, Mark, everyone can get your information directly from this slide. They can also go to Levelset and post questions. We look forward to working with you and your whole firm at developing a closer relationship and getting some of your thought leadership and all the great things that you're doing in Georgia, and helping clearing this up for people and really help contractors and subcontractors and really the whole construction industry with navigating this new law. So thank you so much. We really appreciate it.
Well, thank you, Seth. Thank you, Levelset. And seriously, anybody email me, call me. I'll be glad to answer the questions best that I can.